Secrets exposed in court. Elon Musk does the impossible against the FCC. In the heart of Boston, under the watchful eyes of millions, a tense silence hung over the United States Supreme Court. At the center of the room, Elon Musk, the man behind the digital revolution, faced Judge Marjorie Whitman, a figure feared even by her peers. She stared at him coldly, her sharp voice echoing through the courtroom. "Mr. Musk, do you understand the gravity of the charges made against your company?" He simply nodded, not breaking eye contact, and then calmly opened a brown leather folder on the table. A faint rustling of papers was heard. The audience, the judges, the press, all held their breath. Inside there was something no one expected. Something that could change the game, not only for Elon Musk but for the future of digital freedom in the United States. What had seemed like the final chapter of a regulatory battle was about to become the start of a constitutional earthquake. The charged atmosphere signaled an imminent twist. The question in the air was no longer whether Musk would be convicted, but rather, what was the FCC trying to hide? The case against X Corp didn't come from nowhere. The Communications Act of 2023, passed amid a rising wave of online misinformation, established strict guidelines for content control on platforms with more than 50 million active users. The FCC, the federal agency responsible for overseeing communication within the country, argued that Musk's company had failed to comply with several protocols required by the new legislation. Among them, the absence of automated filters for sensitive content, refusal to provide user data considered of investigative interest, and failure to meet deadlines for responding to official notices. For prosecutor Dennis Hollings, it was a clear case of deliberate negligence. X Corp acted as though it were above the law, he declared in an accusatory tone. Beside him, technical attorney Claire Duval supported the case with numbers, reports, and legal articles, all pointing to an alleged institutional defiance by the company. Outside the courtroom, the case had become a national spectacle. On one side, politicians demanded exemplary punishment. On the other, defenders of digital freedom saw the trial as a covert attempt by the state to control public discourse. In the streets of Boston, posters spread with phrases like, "Regulation is not censorship," and "Musk must answer." Inside the court, however, there was only tension. Every gaze was fixed on the approaching clash. What was being judged was not just a company, it was the future of the digital space in the United States. Marjorie Whitman, 58, presided over the Supreme Court with the authority of one who had already shaped historic decisions. Conservative in her interpretation of the Constitution, she was known for her technical rigor and never yielding to political or media pressure. Her imposing presence in the courtroom commanded respect. That morning, her expression was stern. She did not tolerate unfounded challenges. Elon Musk, for his part, seemed restrained. At 53, used to dominating rooms with his visionary charisma, he now appeared carefully reserved. He knew any slip-up would be amplified. His history as a disruptive entrepreneur contrasted with the formal atmosphere of the court. There he was not a billionaire, he was a defendant. Representing the FCC, prosecutor Dennis Hollings stood out for his firm, almost provocative tone. Known for his relentless approach in regulatory cases, he treated the trial as a turning point for state power. Next to him, Claire Duval, the commission's attorney, exuded technical confidence and legal security. Each character was in position. The court was ready. But what no one there could have imagined was that the most unexpected argument would come from the one who seemed cornered, and would change everything. The session progressed with growing intensity. Judge Marjorie Whitman took charge of the interrogation with unyielding firmness. Her questions were sharp, technical, meticulously formulated to trap. She demanded direct answers about X Corp's failures to comply with the Communications Act of 2023, pointing to specific clauses and confronting Musk with reports produced by the company itself. Musk maintained his composure. He responded with precision, avoiding any direct confrontation. His tone was respectful but carried a quiet conviction. He was not trying to please the court, only to make it clear that there was another truth beyond the narrative presented by the FCC. With each answer, the atmosphere grew denser. Claire Duval, strategically positioned next to Prosecutor Hollings, intervened with documents and supplementary data, reinforcing the accusation. The court observed in absolute silence. On the side benches, the other judges, Lucinda Marlowe, Omar Reyes, Helena Torres, and Brian Sutter, exchanged discreet glances, attentive to the nuances of the clash. The media, positioned in the upper galleries, avoided any noise. The entire country was watching the unfolding of what was already being considered the trial of the year. The balance seemed clearly tilted in favor of the prosecution. But no one there knew what Elon Musk had brought inside that leather folder, now resting closed on the table. It was then that Elon Musk, with the same calm he had maintained from the beginning, opened the leather folder again on the table. He took out a single sealed envelope. He handed it to the court official, who took it to Judge Whitman. The ensuing silence was absolute. Inside, there were copies of internal FCC emails revealing that the agency had deliberately omitted technical studies that pointed to the ineffectiveness of the protocols required by the Communications Act of 2023. One of the documents was particularly explosive, a note signed by an FCC director admitting that the imposition of automatic filters is legally fragile and could be overturned based on constitutional precedents. Musk stood up, asked for permission to speak, and cited one of these precedents. Harrison v. Oregon Tech Board, a 2017 decision, written by none other than Judge Marjorie Whitman herself. The court froze. In that case, Whitman had argued that no administrative agency could surpass the limits imposed by the First Amendment. The tension in the courtroom became almost physical. What had seemed like a timid defense now revealed itself as a meticulously planned attack. For the first time, control of the session was no longer in the hands of the prosecution, but in Elon Musk's hands. The revelation hit like a bombshell. For a moment, silence overtook the courtroom. Then came the reactions, fast, intense, uncontrollable. Judge Omar Reyes was the first to break the stillness, requesting an immediate copy of the presented documents. Helena Torres, typically composed, raised an eyebrow, visibly surprised by the mention of the Harrison v. Oregon Tech Board decision. Judge Whitman, previously inflexible, flipped through the papers with a tense expression. Her face showed no anger but something deeper, discomfort. The words she herself had written years before now came back with unexpected force, used against the foundation of the case she had helped support. Prosecutor Dennis Hollings attempted to counter. He argued that the documents were out of context, that the emails didn't alter the key facts of the case. But his voice no longer carried the same authority. Claire Duval remained silent, staring at the table before her, her lips pressed tight. The mood in the room had completely shifted. The press noticed. Photographers captured every detail. The tension was no longer between Musk and the law, but between the court and its own contradictions. For the first time, the prosecution seemed weakened. And Marjorie Whitman was facing her own jurisprudence. With the documents in hand and the constitutional precedent exposed, the court was forced to shift the focus of the discussion. The trial, previously centered on X-Corp's alleged negligence, began to revolve around a deeper issue: the limits of regulatory agencies' power against the Constitution. The topic of digital free speech emerged as the true center of the case. Judge Omar Reyes, known for his sensitivity to civil liberties, was direct. We are facing a possible structural abuse. The question now is not whether X-Corp failed, but whether the FCC has overstepped the boundaries our Constitution imposes on the state. Judge Helena Torres added, if precedents like Harrison v. Oregon Tech Board still hold weight, and I believe they do, then we must reassess the legitimacy of the mechanisms required by the FCC. At that moment, it became clear that the discussion went beyond Musk. It was a clash between regulation and freedom, between state apparatus and digital autonomy. Even Whitman, though restrained, seemed to absorb every word. Her eyes no longer challenged Musk but examined the very foundations supporting the prosecution. The court was no longer judging a businessman. It was judging the very instruments of the state. After long minutes of silent reflection, Judge Whitman finally spoke. Her voice, usually firm, now carried a slight hesitation. She asked for the floor and, with a look directed at the other judges, began to reconsider the course of the trial. This court cannot ignore the very constitutional principles that have guided us in past decisions, she said, clearly moved by the precedent now at the heart of the debate. The court, in unison, seemed to process the magnitude of what had just happened. Whitman, recognizing the complexity of the case, proposed a review of the FCC's demands, suggesting that the agency reconsider its guidelines in light of the Constitution and digital freedom. The prosecution, once dominant, saw its ground crumble. Musk, though still cautious, was the first to speak, thanking the court for its impartiality and for the attention given to the Constitution. His posture now seemed calmer, as if the weight of the trial had somehow shifted to the regulatory agency. The verdict was clear: the FCC would need to review its practices. However, the consequences for Musk and X-Corp were still to be defined. The impact of the trial would extend beyond that courtroom, reverberating throughout the country. The FCC versus X Corp trial became a historic milestone, sparking intense debates in law schools across the country. Universities, now buzzing with discussions on digital regulation, saw the case as an example of balancing free speech and state intervention. In the Senate, a new bill emerged proposing adjustments to the regulation of digital platforms. Elon Musk, for his part, published an article titled "Freedom Cannot Be Silenced," advocating for the protection of digital freedoms against the growing power of government agencies. The era of digital regulation would never be the same. And so, the trial that redefined the limits of digital freedom comes to an end. But the real question still hangs in the air: how will we balance state power and individual freedom in the future of the internet? If you've been as engaged as we are, don't forget to like and share your thoughts in the comments. We want to know what you think. And, of course, subscribe to the channel for more stories that challenge the status quo and make us question the world around us. Stay tuned for more exclusive content. Until the next chapter.